Good morning, everyone. My name is Madison Garzoli, and I'm the Director of Membership and International Programs at Sonoma County Vintners. Thank you all for joining today's webinar. We have Leah Cameron with CDF Labor Law joining us today to present to you all a fantastic presentation on some employment law updates for 2021 and moving into 2022. Just a few housekeeping items before we begin. One, this is being recorded, so we will be posting this to our YouTube playlist and also sending it via email next week with all the Q4 planning for 2022 series recordings. Secondly, if you have any questions during the presentation, please direct those questions or comments in the chat. And third, I sent out the handout that includes the PowerPoint presentation and areas where you can take notes. I will be also dropping a link in the chat in case you were unable to locate that. That'll directly link to the PowerPoint presentation, and you can reference that on another screen or quickly print that out. So without further ado, I will turn it over to Leah.
Thank you, Madison. It's a pleasure to be here giving you this, what has become my annual employment law landscape update for Sonoma County Vintners. We've been doing it here for a few years now, and I'm happy to be doing it again this December and hoping that maybe by next year we will all be in person, because it's really just always a pleasure to see all of your faces and get to know you and just have the feedback of that in-person interaction. But for today, we are grateful to be online, conveying this information to you. Again, my name is Leah Cameron, and I'm a partner at the law firm of CDF Labor Law. I work out of our San Francisco office, but I actually live in Petaluma, so I am reporting live to you today from Sonoma County, and happy to be part of your community and all of the work that Sonoma County Vintners and your community does. So I work out of our San Francisco office, but our firm, CDF Labor Law, has offices all across the state of California. We have all the major metropolitan areas covered, and we represent employers exclusively. We don't represent employees. We represent employers in exclusively labor, employment, and immigration matters. So we cover the full spectrum of labor and employment law with respect to both litigation and providing advice and counseling to our employer clients. A couple of housekeeping items, some of which Madison has covered. The presentation materials were emailed to you, but they are also now in the chat. You should be able to follow the link that Madison put in the chat if you want to go there and download it. This is a 60-minute webinar, but I think we'll probably be done today in less than 60 minutes. So I will try to move quickly through the material, but you can also, I will try to open it up for questions as we go through. So if you have questions about the materials that I'm discussing, you can put them in the chat, and I will try to stop intermittently and address those questions as we go along. Okay, so our agenda for today is to cover new California legislation for 2022. We're going to cover the primary new laws. This is not exhaustive. This is a broad overview. And to be honest, if I were to cover every single new law affecting employers, we'd probably be here for 4 hours. Every year we have a lot of new legislation. So that's just the reality here in California, but we're going to cover the important highlights for you here today. We're also going to cover new COVID-19 legislation and regulations for 2022. Again, this is not an exhaustive COVID presentation, but it is an employment law overview, but we are going to touch on some of the major COVID-19 issues. The new issues. If you want a deeper dive into the COVID-19 employer regulations, we are planning a seminar or a webinar, our law firm. So we're doing a focused webinar in late January or February on updated COVID-19 regulations for employers. And so this presentation that I'm doing here today is through Sonoma County Vintners, but my firm also CDF Labor Law does monthly webinars that we open up to all of our clients and prospective clients and anyone who follows us online. So you can go to our website and sign up for updates there. Our website information and my contact information is at the very end of this presentation on the last PowerPoint slide. So you can always go to our website and sign up there if you're interested in attending that COVID-19 webinar, or you want to find other information on our website. We have a lot of great information on our website, including a whole COVID-19 reference page. And we also have a blog. If you sign up for our blog, then you get regular updates anytime there's any new developments in the employment law arena. So that's COVID-19. We're going to cover some of those highlights today. And then we're also going to cover key judicial decisions from 2021 that affect employers as we move into the new year. And then we will talk about some of the other issues of concern for 2022 on a political governmental level that affect employers and their status as employers. Okay, so talking first about new California laws, all of these laws that I'm going to be discussing with you now go into effect January 1st, 2022, unless I indicate to you otherwise. Okay, so you have a few more days to get into compliance with each of these new laws that I'm going to be discussing, except there's like maybe one or two that are already in effect. And I'll let you know when we get to those. The first new law is the expansion of Cipra. So Cipra, if you will recall, is that law that provides that employers must provide eligible employees with up to 12 weeks of job protected time off of work annually to care for an immediate family member with a serious health condition. Now, there's a lot there. I'm not covering exhaustively the contours of Cipra because that law has been in effect for quite some time. But this new bill changes and expands Cipra to provide that parents-in-law are now considered part of the list of qualifying family members with serious health conditions for which you must allow an employee to take leave. So it's just expanding the coverage of what it means to be an immediate family member protected under Cipra. This is a cleanup bill from a separate bill, Senate Bill 1383, which was actually passed in 2020, that did include parent-in-law into one of the definitions, but then omitted it from the substantive list of covered family members. So it wasn't clear if parent-in-laws were included or not. So this bill was passed to clarify and fix that confusion. So parent-in-law is defined as the parent of a spouse or a domestic partner. So for you as employers, the action item is to make sure you've updated your own Cipra policy to make sure that parents-in-law, care for a parent-in-law is now protected and covered by Cipra. This next Senate bill or Assembly Bill 701 has to do with warehouse distribution employees. And I don't think any of you would qualify as a warehouse distribution employee, but I did just want to touch on it briefly because this can affect potentially your distributor or wholesaler shipping relationships, right? So what this new law says is that employers with at least 100 employees at a single warehouse distribution center in California or 1,000 employees at multiple centers must provide their employees with written descriptions of the quotas that they're expected to meet upon hire or within 30 days of the law going into effect. This does not affect every warehouse distribution center, but it does affect merchant wholesalers of non-durable goods, including alcoholic beverages. So it could involve some of your distributors. And really, what is the effect on you? Well, it could, we don't know yet what the impact and cost is going to be on distributors, but this could impact their costs and their ability to quickly move product because it requires the warehouse to provide the employees information in advance about the number of tasks that they have to perform within time periods if they do have quotas of that nature. And I'm just going to move quickly through this since this doesn't really apply specifically to you. But I think what this is indicative of, and that I would want every employer to be aware of, is just that unionization is a very strong force right now, and that's why this bill was passed, because the California legislature currently generally backs all union-backed legislation, and unions have been for years upset about quotas in the warehousing industry, and they are trying to make it more challenging for warehouses to implement and enforce these aggressive quotas. So it is just indicative of this overall pattern that we see of increased unionization support and support for any union-backed legislation, and also just the expansion of union influence into traditionally non-unionized workforces. Moving on to settlement agreements, there's a new assembly bill called the Silenced No More Act. You may recall a couple of years ago in California, there was a law that was passed that was pushed forward by the Me Too movement. And that was to prevent settlement agreements involving sexual harassment claims from prohibiting disclosure of the underlying facts alleged. So this new law is a building block on top of that, because now, in addition to prohibiting settlement terms that prohibit the employee from talking about the underlying sexual harassment, you are now prohibited from having that kind of a term in any settlement of any harassment, discrimination, or retaliation allegations. And any agreements that have such a confidentiality term are subject to be stricken. They're unenforceable by law. And this takes effect on January 1st of 2022. So if you enter into a settlement agreement with someone who has alleged any type of harassment or discrimination or retaliation, not merely on the basis of sexual harassment, but also, any protected category. So disability, gender, race, national origin, any type of protected characteristic, you cannot have a term that requires them to keep the allegations of harassment and discrimination confidential. And if you do, you may have spent thousands or tens of thousands of dollars negotiating this settlement. You pay them the money, but your settlement agreement is going to be void because it contains this unlawful confidentiality provision. So be very careful. Be very careful about making sure if you use, especially if you're a smaller employer, you may have like some template severance agreement or some template settlement agreement that you use with terminated employees. Maybe when you fire an employee, or if they come back to you later and try to assert a claim, you may use these templates, but just know that those templates starting January 1st of next year, 2022, are probably going to be unenforceable. And so they really need to be revised, preferably by an attorney, to help you remove some of the no longer lawful language about confidentiality. Let's see. Moving on to our next slide. Okay, so in addition, you technically can still have a non-disparagement clause in your settlement agreement, but you must put this italicized language in the settlement agreement right next to the non-disclosure language. So essentially the employee, you have to tell them that even though they're agreeing to non-disclosure, they are allowed to discuss publicly the alleged unlawful acts of harassment or discrimination, that if they believe those acts to be unlawful. Now, those acts don't actually have to be unlawful. They just can say that they thought they were unlawful, and now they're allowed to talk about these issues on social media, to the news, to their friends, and if you have a non-disparagement clause, as a term in settlement agreement saying that they can't disparage your company, you have to then put in this information telling them, oh, but you are allowed by law to talk about all the alleged harassment. So here's the problem. If it's so important to you to put in a non-disparagement provision in your agreement, which, you know, a lot of employers want for good reason, but then you have to put this language in the agreement that basically broadcasts to them that they're allowed by law to talk to everybody about the alleged harassment, I don't think that non-disparagement clause really has much value to you anymore. It actually might do more harm than good, because you're telling them that they're allowed to talk about the harassment, which maybe before they wouldn't have known or been sure about. So I think the value of non-disparagement clauses in any kind of discrimination or harassment situation has pretty limited and maybe negative value at this point. Now, I will say, though, let me just be clear that you can still keep the amount of a settlement confidential. You can still require, as a term of your settlement agreement or your severance, that they keep the amount of the settlement confidential. You just can't require them to keep the allegations of the underlying alleged harassment or discrimination or retaliation confidential. So this is a big thing for employers, because this is, you know, confidentiality and non-disparagement is something that I always bargain hard for in settlement agreements. It's something that you really do want to purchase as part of your settlement with this, you know, would-be plaintiff, but it's not going to be allowed anymore going forward. So one thing to know is if you are on the fence with someone, if you're negotiating a severance with somebody right now, or you have a problematic employee that's threatening to bring claims, you may want to get that resolved before December 31st so that you're not subject to some of these new settlement restrictions. One other component of this is that now, when you're negotiating that settlement and you make them that settlement offer, you have to give them 5 business days to consider the agreement before they sign. They can sign earlier if they like, but they have to be provided with at least 5 days. They need to be notified that they have a right to consult an attorney and that they have at least 5 days to do so. They can sign right away if they like. And this is not a revocation period. It's not saying that they can sign and then revoke it for 5 days. It just says that they have 5 days. They have to have 5 days to consider. And so that is the right to consult with an attorney and consider for 5 days should be incorporated into the language of your severance agreements or your settlement agreements. So if you have some templates that you use, those should be updated for this purpose as well. Okay, so moving on. One more thing I want to tell you about this is that a lot of times, you know, employers, I will see that if they have severance forms that they use, they may have the employee sign it, and then they don't sign it because they figure, well, they can sign it any old time. The employer can sign it whenever they want. But actually, for it to be an enforceable contract, it needs to be fully entered into by both parties. So both parties need to sign. And in this specific instance, you want to make sure that you have signed, your company has signed before December 31st. Otherwise, it's going to be subject to the new, you know, if you sign it in 2022, it's going to be subject to these new settlement agreement restrictions. And I, you know, there are lots of problems with signing something and then backdating it. So I wouldn't recommend that either. So make sure you get your agreement signed before the 31st if you've got that pending. Okay, moving on to arbitration fees. So some of you may have arbitration agreement programs with your employees, others may not. There are a whole host of reasons why companies do or do not choose to have arbitration agreements with their employees. But in California, the legislature, the California legislature and the judiciary, they hate arbitration, and the U.S. Supreme Court loves arbitration. So there's a bit of a battle going on. The U.S. Supreme Court supports arbitration, says in case law that it's the preferred remedy for resolution of disputes so as not to overburden our court system, to allow the parties to engage in expeditious informal resolution of their disputes. But California courts and the legislature, by contrast, prioritize consumer protection and employee protection more highly. And so they keep trying to chip away at arbitration agreements and their enforceability without violating the US Supreme Court federal rules on that subject. So 2 years ago, a bill was passed that said if you have a mandatory arbitration agreement and you've initiated arbitration, you're in an arbitration with someone, and they and you do not pay your arbitration fees on time or within 30 days of the invoice, the party compelling the arbitration, which is most likely you or your company, is going to be found to be in violation of that arbitration, and the case will get kicked out of arbitration and sent back to court. So the takeaway here, just quickly for you guys, is that you've got to make sure if you're in arbitration that those arbitration fees are paid timely, because if they're not, you could lose your arbitration jurisdiction and you end up back in front of Superior Court. So if you're responsible for paying your arbitration fees, don't send the checks by mail. Don't just forward it to your accounts payable department and forget about it. Make sure it gets paid. Make sure that the checks get overnighted to the arbitrator so that you don't lose the jurisdiction of your arbitrator. Something that will pertain to all of you is the personnel records retention change in the law. The current retention requirement has been 2 years, but it is now extended to 4 years from the date the records were created or the employment action was created. So I would say best practice is after if you terminate an employee, keep their personnel file for 4 years, because even if some of their personnel file that pertain to the beginning of their employment is more than 4 years old, sometimes it's difficult to say what's going to become relevant at a later time. So best practice is just to keep the file for 4 years after termination. An additional term of this Senate bill is a tolling of the deadline for the DFEH, the Department of Fair Employment and Housing, to file civil actions. So it used to be the timeline for the DFEH to investigate used to be shorter, but now when a complaint is filed with the DFEH, the time for complainants to file their own lawsuit against their employer would be tolled until the DFEH files a civil action or 1 year after the DFEH issues a written notice to the complainant that it has closed its investigation. And also, it's not on the slide here, but the DFEH also has 2 years to investigate class claims. So what this means for you is just that claimants have more time to bring their actions to court than they used to. And that's an additional challenge for employers because, let's say you terminate someone's employment and the manager who was involved in that termination, they leave your company, they're not there 2 years from now. And so or maybe they move out of state, or they have you have a contentious parting of the ways with that manager. So the more time passes, the harder it is to just get those witnesses, to find them, to locate them, to help you defend your company against the claim. And people just forget, right? As time passes, memories fade. I know my mind is like a sieve. I've got 2 small children and a lot going on, and I can't remember. So after 2 years, memories are really starting to fade. And that's just an additional challenge for employers to try to defend, their terminations and their adverse employment actions with their employees and former employees. So moving on to the next slide, Osha. I think, before the pandemic, a lot of us didn't think too much about Osha and their scope of authority, but the pandemic has had the effect of substantially increasing Osha's presence and powers in a variety of ways. The one here on this slide that was recently enacted creates a rebuttable presumption that an employer with multiple work sites has committed a, quote, enterprise-wide violation, which carries higher penalties than some other violations, if Osha determines that the employer had a non-compliant written policy or procedure, or Osha has evidence of a pattern or practice of the same violations involving more than one work site. So if Osha believes that they see one of those two things, they can rely on a presumption that this was an enterprise-wide violation, which subjects you to harsher and stiffer penalties than you might have previously seen for those health and safety violations. In addition, Senate Bill 606 gives Cal OSHA the authority to recognize a new type of egregious violation when certain conditions exist. And if an egregious violation is found, they have to cite you. The citation is mandatory, even if you abate the condition giving rise to the citation. So all of this is just demonstrating harsher penalties for health and safety violations in the workplace, and more power for Cal OSHA to pursue those penalties. In addition, Cal OSHA now can more easily obtain an injunction against your business if they believe that there's a health or safety violation. Currently, Cal OSHA can only seek injunctions against your business if the condition constitutes a serious menace to the lives or safety of your employees. But under this new bill, Cal OSHA can seek an injunction restraining certain operations anytime it has grounds for a citation. So this greatly impacts their ability to issue injunctions that immediately constrain the operation of your business if they think there's a health and safety violation. So the takeaway for employers is that it's imperative that your written policies and your procedures are compliant, so that you don't find yourself in a situation where the Cal OSHA makes a finding of a enterprise-wide violation. So you want to make sure your written policies are good, and also that your regulatory compliance is on point, not just at one location, but across all of your work sites, just in case Cal OSHA comes knocking and wants to do an investigation. I will just put a little plug in here to say that at CDF Labor Law, we do have one partner, my partner Tom Song, who is an attorney with our firm, who used to work for Cal OSHA. So he focuses his practice entirely on Cal OSHA issues and occupational safety. So if you need support in that sphere, we do have expertise, and I would be happy to connect you with Tom to help you out with any of those issues. Moving on to criminalization of wage theft. So what this bill does is it makes the intentional theft of wages, including the unlawful retention of portions of gratuities or any other intentional unlawful retention of an employee's wages, grand theft, particularly if it's in an amount greater than $950 for any one employee, or $2,350 in the aggregate for two or more employees within a 12-month period. And this makes it a crime. So in California, you can be imprisoned for up to a year for committing a misdemeanor, and 2 to 3 years for committing a felony. So, and there are also monetary fines that can be attached, but they're criminal convictions, and monetary fines and jail time can be attached. So you do want to make sure that you are not unlawfully retaining any portion of your employees' wages. And also, to the extent that you use staffing agencies or farm labor contractors, you want to make sure that their own wage and hour compliance and labor code compliance is in order, because this bill includes independent contractors. And so you do not want to be responsible for the criminal wage theft of a farm labor contractor that you're working with. And someone recently said to me, wow, we're not really prosecuting shoplifting in California, but we're criminalizing wage theft. So this is just, I guess, the cost of doing business in California, and it is where we are today. Tip distribution for food delivery employees. I'm not really going to go into this much because you guys are not food delivery platforms. But to the extent that any of you may work with a food delivery platform, they are required not to retain any portion of the tips that are meant for their delivery drivers, and also any receipt has to provide a cost breakdown of every transaction, both for the customer and the food facility. So if that involves you, just be aware that that tip breakdown does need to be in the bill. So before I move on to COVID-19 legislation, I don't see any comments in the chat. So I'm going to move on, but feel free to enter your questions in the chat if you would like to. Moving on to COVID-19 regulations, Assembly Bill 654 modifies a prior bill that clarifies the COVID-19 reporting requirements if a COVID-19 case emerges in your workplace. You have to provide all employees and subcontracted employees on the premises at the same time as the employee who has COVID within the infection period. Within 1 business day, you have to provide them written notice that they have been exposed, the cleaning and disinfecting plan, and you have to also provide them of all state and local COVID-19 related benefits. You have to provide them notice of what those are. And if you have more questions about specifically how those terms are defined, I mentioned earlier at the beginning of this presentation that we have a great COVID-19 reference page on our CDF labor law website at cdflaborlaw.com. So you can get more specific information about these terms, but note that you only have 1 day to provide that written notice, or actually 48 hours, if whichever is later, such as over, this is like if you have a weekend situation, whichever is later. So how do you provide the notice? Well, text or email is going to be considered a sufficient writing as long as you can reasonably expect that it will be received. So if you get email bounce backs, that is not sufficient. You're going to need to find another way to confirm in writing with this person that you've given them notice. You know, posting something on like a message board in the break room is not going to be sufficient, because you need to be able to reasonably believe that everybody's going to see it and receive the written notice. The notices can be in English, but if a majority of your employees or subcontracted employees, if you're talking about, you know, a subcontractor, a labor contractor that has a majority population that speaks another language, such as Spanish, then you want to make sure that the notice is in that language. There are some additional provisions for union employees, but I don't think any of you have unionized workforces, so I'm just going to move on from there. If there is an outbreak, so an outbreak is 3 or more COVID-19 cases within a 14-day period. If there is an outbreak, the employer must notify the local public health agency of the names, number, occupation, and work site of the employees who meet the definition under the code and of any person who's had COVID-19. So you should probably, honestly, if you have an outbreak, which is 3 or more cases within 14 days, you should probably consult with an attorney to make sure that you are complying with all of your reporting obligations, because it does get a little more complex when you enter into this outbreak sphere. This is the one piece of legislation that we're talking about today that has already gone into effect. So it went into effect on October 5th of this year. The day it was signed. It is supposed to expire January 1st, 2023, which, you know, we'll see some of these rules get extended. We just never know when this pandemic is going to subside, but I guess they're hoping that by 2023, they can do away with this legislation. So we will have to see. Fingers crossed, right? Okay, so before I move on from there, are there any questions about the COVID-19 regulations that I've covered? Okay, I don't see any more. Don't see any comments. So I'm just going to keep going and move into the key judicial decisions affecting California employers. There are a couple key decisions, not as many as we've seen in some prior years, and I think that is Probably due to the fact that our court system has slowed down a lot. And that's just something to know for you guys as well, is if you do get involved in a lawsuit, it is harder to get time in front of the court. The court system has slowed down drastically during COVID. It was shut down at the beginning of the pandemic, and we're still dealing with the backlog. And then all of the remote requirements now just keep things moving very slowly. So it's hard to get in front of the judge to have your disputes adjudicated. And I think that's probably part of the reason why there are fewer judicial decisions this year. But there was at least one that was shockingly favorable to employers. I feel like I usually have negative information to report to employers, but today I have at least one good case to report to you. And one of the trends that we've seen this year is an uptick in Poga and class action litigation. Now, Poga litigation is the Private Attorney General's Act, and it is sort of like a class action in the sense that it's a representative action where the employee is seeking to represent not only their own claims, but the claims of other employees who they claim to be similarly situated. But the difference between a class claim and a Poga claim is that in a Poga claim, the plaintiff is standing in the shoes of the state attorney general, seeking to recover penalties on behalf of the state and their coworkers for alleged violations of the labor code. So they can't actually get damages. So damages would be like unpaid wages that they claim they didn't receive, that they and their coworkers didn't receive. That they would have to pursue via a class action. But in a Poga action, they can seek to recover the penalties that the state would normally be seeking for those technical violations of the labor code. So Poga actions, they can affect small employers and large employers alike. I've seen some relatively small Poga actions. And unfortunately, we have really seen an uptick in that litigation this year. Plaintiffs' lawyers have been very busy filing Poga claims. So one of the decisions that was an important decision for California employers this year was the Megadia versus Walmart decision. And this was a Ninth Circuit federal court decision that held that the named plaintiff in that case lacked standing to pursue a meal period premium claim where he personally didn't suffer a meal period violation. And this decision was departing from the California State Court authority that we were previously under Huff versus Securitas, which allowed an uninjured plaintiff, so an employee who was not injured, from maintaining a Poga claim on behalf of other aggrieved employees who allegedly suffered the alleged injury. But Megadia said that in that case, the plaintiff had a wage statement claim, and his wage statement claim was different than the meal period claim that he was trying to assert. So he could assert his own wage statement claim, but he couldn't assert a meal period claim on behalf of other employees where he himself did not suffer a meal period violation. That's a lot of kind of technical legal information that's very important to us as defense attorneys. But I think for all of you, the takeaway is that Huff versus Securitas is still the law in California, but this Megadia case is the federal authority. And so while the Megadia case is not binding on the California state courts, it does provide us with a roadmap of how to defeat some of these overbroad Poga claims. And also, to the extent that if you're facing a lawsuit in state court, if you can get your case removed to federal court, that's going to be a much friendlier forum for you overall. The next case I want to discuss is the Wesson versus Staples case. This is a California Court of Appeal case. So this is a California court. So it applies to us in state court. And the court there held that judges have inherent authority to limit and strike unmanageable Poga claims. So this case dealt with the misclassification of general managers. Staples, the store chain, argued that each site manager, each general manager's job duties were different depending on the store where they worked. And that because of that, each of their claims were different. And so it was inherently unmanageable to litigate them all in one case. You couldn't just have one trial and the evidence would pertain to everybody, because everybody's job duties and fact situation was specific. And the court agreed and said, yes, the trial court has discretion to strike or dismiss a Poga claim if it is unmanageable. So we are hoping that this will help curb some of these unwieldy, overbroad Poga actions from proceeding. Now, there haven't been a lot of cases yet interpreting Wesson, but we hope to see more cases interpreting and confirming this manageability analysis going forward in the new year. Finally, we have the Farah versus Lowe's case. This case is not favorable to employers, but it's something that employers need to be aware of, especially because of its retroactive effect. So the California Supreme Court, and this is important to all of you who have hourly employees, the California Supreme Court concluded that when an employer fails to provide an employee with a compliant meal or rest break, the employee is entitled to a premium payment of 1 hour of pay at the employee's regular rate of pay, as opposed to their base hourly or their straight time rate of pay. So historically, hopefully all of you have been aware of your obligation to provide timely meal and rest breaks to your employees. The details of those requirements I'm not going to go into here, but when you fail to provide a timely, proper, legally compliant meal or rest break, historically employers were required to pay a premium payment in the form of 1 hour of pay. And most employers were just always paying that premium payment at the base hourly rate. So if you have an employee who works for $16 an hour, you would be paying them a premium if they missed their meal period of $16. And you did not typically in the past factor additional forms of compensation into that hourly rate, as you do actually with overtime. So hopefully you've been calculating your overtime to include any non-discretionary bonuses or other components of compensation. So essentially what that means is, let's say you have like an attendance bonus or a quota bonus. If they make a certain number of sales, they get a $500 bonus. Then that bonus has to be factored into the regular hourly rate of pay for purposes of calculating their overtime premium. Well, employers have been, hopefully, you have been previously doing that when you calculate your overtime, but this new decision says that now you have to factor that in to come up with that regular rate of pay, just like you were doing with overtime. You have to do it for your premium payments as well. Now, the real problem with this decision is that it is retroactive. So now, not only do you need to change your your method of calculating the amount of pay for premium payments going forward, but you need to consider retro paying any missed meal or rest break premiums going back into the past. Now, is this going to lead to employers doing away with any kind of non-discretionary bonus pay or other units of compensation? It's not just bonuses. So it could also be like, let's say you pay your employees like a shift differential. You give them an extra bump for coming in and working on the weekend, say. Well, that has to also be factored into the regular rate. And it was already complicated for purposes of calculating overtime, but this is just one more complication in how you calculate those meal and rest break premiums. So California law, I think, really does discourage employers from providing any kind of non-discretionary bonus plans or other extraneous forms of compensation. And if you are going to provide those forms of compensation, you can, and they do incentivize employees, but you just have to make sure you're calculating your meal and rest break premiums and your overtime correctly. And it is extremely complicated. And you can engage counsel to help you figure that out if you're not sure how to do it, because it is pretty tough. Because it's retroactive, some employers are going back and trying to pay the correct amounts, paying that difference. Let's say the hourly rate is $16 an hour, but with the regular rate calculations, it's more like $17.50. So do you go back and retro pay that $1.50 difference? Some employers are just crossing their fingers and hoping they don't get hit with a lawsuit for failure to go back and retro pay it. But if you do go back and want to do the retro pay, that's something that we can help you with, and an attorney can help you do, because you want to do it carefully to make sure that you're treading lightly, because you risk alerting employees to the problem. So you want to make sure that you're just judicious in the way you go about formulating those communications. Why would you go back and do a retro pay? Well, because if you wait until you're hit with a lawsuit, you're going to have to pay the plaintiff's attorney's fees and potentially penalties, the civil penalties, which apply for each pay period in which there was an underpayment, on top of whatever that minimal wage differential actually is. So you want to, at the very least, make sure you're compliant going forward. But when you consider retro pay, I do see a question here about how far back you need to go. Okay, that is a great question. The Poga statute, the penalty statute, has a 1-year statute of limitations. So if you make your if you make the correction now, then by December 2022, you will have run out the statute of limitations. So you have to go back 1 year to carve out any Poga liability. But if a plaintiff were to bring a class action, which they could do for this retro pay, then it's a 4-year statute of limitations. So if you wanted to do the most conservative approach, you would go back and correct the premium payments going back 4 years. Let's see, moving on. Okay, I see a question about, do tips need to be considered for the regular rate of pay? That is a great question. And I think the answer to that is no, because when you any component of compensation that needs to be factored into the regular rate is anything that is other than completely discretionary. So let's say you give your employees a Christmas bonus and it is not tied to their performance. There's nothing about the award that says, this is in recognition for your hard work and good performance. If there's anything non-discretionary about it, it does need to be included in the regular rate of pay. But if it's 100% discretionary, it is a gift at the end of the year, then that does not need to be factored into the regular rate of pay. So tips, if you have some kind of like automatic 20% gratuity, then that creates more of a gray area, right? But if they are just tips that customers are giving to employees that is completely discretionary, then those I do not think need to be considered part of the regular rate of pay. Okay, so Megan's question is, if the tips are dispersed in the paycheck and the amount you get is based on the hours you work. Wow, Megan, that is an interesting question. I have to say, I don't know the answer off the top of my head, so I'm going to go back and I'm going to find out the answer to that question, because I think typically the tips are going to be discretionary and don't need to be part of the regular rate. But if there is some kind of pro rata distribution based on hours worked, could that change the nature of their character? Potentially. So I'm going to look into that and follow up with Megan. And if you're interested in knowing the answer to that question, reach out to me separately after the presentation and I will get that to you, because that's a very good question. Okay, so I'm going to move on to, there's one more, this is just another Poga settlement decision that says if you are facing multiple Poga cases, and I hope none of you are, But if you are, then, sometimes one of the things you try to do is resolve them all at once. And so one of the things you can do is try to settle out the later case that's been filed with a settlement agreement that backdates the statute of limitations to cover the previously filed cases. And this Turrieta case says that you can do that. And that's because the statute of limitations is the employer's defense to waive. And so if you as the employer want to waive that defense, then you can agree to release older claims that are outside the statute of limitation and thereby expand the time of the covered period in the settlement and have the effect of settling out multiple cases through that one later filed case. This is just a strategic maneuver that you can utilize if you're facing multiple overlapping cases, and you'd want to work with your attorneys on that strategy because it does get a little complex. Okay, last couple issues that I want to talk about before we end today are other issues of concern in 2022. So I've alluded to some of these before, and at the risk of getting political, I don't necessarily like to talk about politics with anyone, but to the extent that it impacts your position as an employer, it is relevant, and particularly in the context of this pro-union movement that we're seeing right now in the employment arena. I think sort of despite what some consider the Biden or expected the Biden administration to be a somewhat moderate Democratic presidential candidate, moderate Democratic president, it is a very pro-union administration, probably more so than any president in my lifetime and probably most of your lifetimes. We're seeing a lot of changes to the makeup of the National Labor Relations Board and the Department of Labor that are very pro-union, pro-employer, and so really lending support to giving more power to unions to organize in additional industries where there has not previously been union organization. So it's just something to keep your ears open and your ear to the ground on what's happening within your industry and how it might be affecting the industries that you work with, such as your distributors, and just something to keep tabs on. There continues to be what I would call an attack on the gig worker and independent contractor arrangement. So I know we've had conversations in this forum in years past during this, prior years of this employment law update, talking about the independent contractor rules. Because we had a decision a few years ago, a court decision that made it much harder for employers to designate workers as independent contractors and almost impossible in any situation other than like a true contractor relationship where they're doing something that's totally outside the scope of your wine business. So let's say, a plumber or a drywaller, right? Or a carpenter, that would be a true independent contractor. But anybody who's doing work that's related to the field that you're working in, wine production, wine sales, those are not going to be valid independent contractor agreements. And so what you have to just be aware of is that there's this constant tug of war between the state government trying to make it more difficult for gig worker arrangements, and then a lot of the tech companies and these gig worker tech platforms pushing back. And so they keep going back and forth, and the state of the law is constantly kind of shifting, but the legislature is always trying to make it more difficult for that independent contractor relationship to exist. And so you should know that if you are engaging workers as independent contractors, it is going to be heavily scrutinized by plaintiffs' attorneys. And if and when that independent contractor relationship with your business sours and they come back and try to make a claim that you misclassified them as an independent contractor when they should have been treated as an employee, that's a very popular area of law to pursue right now by plaintiffs' attorneys, and the law is largely going to be against you. So just be aware that it is very risky to maintain people in that independent contractor classification. unless they truly are a contractor. I just want to touch on the makeup of the California legislature only because you can see here that the assembly is heavily, we have 60 Democratic assembly members and 19 Republicans, 31 Senate members and 31 Democratic senators and 9 Republican senators. So all of that to just say that when the pro-employee, pro-union legislature wants to get something done, they typically have the ability to do it without much of any pushback. It's not like the federal legislature, which is a more evenly split, and so it's harder for the unions and the pro-employee lobby to get legislation passed. So that is just the state of our current legislature, and of course with Governor Newsom in the governor's seat, he is not vetoing any of those pro-employee or pro-union laws, as you can see from the whole first half of my presentation where we talked about all the new legislation that went into effect. Everything that gets proposed is pretty much signed into law. None of them are typically not vetoed. Before Governor Newsom, we did have Jerry Brown, who was also a Democratic governor, but did veto some pro-employee legislation. Governor Newsom is pretty much greenlighting all of it. And then finally, the only last thing I want to say is that the judiciary, while the U.S. Supreme Court has shifted to the right under Trump appointees, and that also pertains to some of our U.S. appellate courts, the state courts have generally shifted to the left, so have shifted more pro-employee, pro-union. And I can just tell you, as an attorney representing employers, the courts are very eager to give employees every opportunity, every benefit of the doubt, and really are more inclined to scrutinize the employers. So it's a challenging environment to be in as an employer in front of the California courts, and I don't think that's going to change anytime soon, but that is the state of the law. So I'm going to just open it up, check and see if there are any more questions here. I don't see any questions in the chat. But if you have any more questions for me after this presentation, please feel free to reach out to me. I realized I didn't put my email address here on this last slide, but I'm going to drop it into the chat right now so you all have it.
And I believe too that your contact information is on one of the preliminary slides as well, just so if anyone needs to reference back to it after this session as well.
Thank you. That's right. That was probably like the first or the second slide. So feel free to reach out to me if you have any questions about anything that we discussed today. And you can sign up for our blog at callaborlaw.com. You can always just go there and search if you have a question about anything that we've talked about today. There may be a blog article on it. You can also sign up for it so that you get periodic updates anytime there's new information. We also have our COVID-19 Resource Center listed there, and you can also follow us on social media. So thank you everyone for your time today. I look forward to hopefully seeing you in the new year. Happy holidays. And I think that's it for today.
Great. Thank you so much, Leah. And thank you everyone for attending. This is our last SCION program of the year. And so wishing you all safe and happy holidays. And we'll look forward to welcoming you back to the SCION series in 2022. So thanks so much.